Hello and welcome to those of you who have just joined us. My name is Geraldine Goes-Kolar. I'm the Deputy Secretary General of the Hague Conference on Private International Law, or HCCH. The next session of CODIFI comprises a fireside chat between two experts, and this chat will analyze the various issues that arise from different holding patterns for digital assets and the possible conflict of laws approaches to those issues. We have with us today for this fireside chat Professor Louise Gullifer and Professor Matthias Haentjens. Professor Louise Gullifer is Rouse Ball Professor of English Law at the University of Cambridge and a Fellow of Gonville and Caius College, Cambridge. She teaches and writes extensively in all areas of commercial and financial law. She is currently co-director of a project on digital assets based at the Commercial Law Centre, Harris Manchester College, Oxford, and chair of the drafting committee of the UNIDROIT Working Group on the private law relating to digital assets. Professor Matthias Haentjens is a full professor of law at Leiden Law School and a deputy judge at the Court of Amsterdam. He has been a visiting scholar at Ghent University, Université de Paris 2, New York University School of Law, and Harvard Law School. He has served as a member of the Experts Group on Securities and Claims at the European Commission and as a short-term consultant with the World Bank. He participates as a working group member in the UNIDROIT projects on bank insolvency and on digital assets. Let's take a listen to what these two experts have to say.
Okay, hello everyone. Hello, Louise.
Hello.
Great to be here. We are in Rome at the moment on UNIDROIT business. We are together working on a project on digital assets, and that's why we're here in this lovely room together. A bit hot, I have to say. But our project is also on digital assets, and that's why I think it's very fortunate that we have a chance to talk to each other in person on this fascinating topic. And what we will be talking mainly about today is on the situation when where digital assets are held by what you could loosely call a custodian, right? Yeah. So what we will be doing is talk about that and also zoom in on what law applies to the different issues that may arise in that particular context. So it may be good to discuss first a bit about well, what are we talking about when we are talking about holding digital assets for clients or custodians holding digital assets? Is that, well, is that just like I would be holding a pen for you, or are there specific issues to be considered when we're talking about digital assets held for clients?
Right. Well, probably the first thing to do is to just very briefly explain what we mean by digital assets in this context. And I think the best way of doing it for our purposes is to talk about what we have been discussing and what we already have in a draft, principles that we've been developing at UNIDROIT. So a digital asset is effectively an electronic record, which will be data plus whatever system that data is held on, and it is the data plus the system that is effectively the digital asset. And the reason I say that is that what's important is that it's not just data, which is just information and can't really normally be seen as an asset, but it's a data that is capable of control. It's capable of control by one person or maybe a small number of people if that one person chooses to share that control. Although what we're trying to do in UNIDROIT is technologically neutral, there are some examples that have been around for some time of these types of digital assets. We can think of things like Bitcoin and Ether, and most of these use cryptographic technology, which means that you have a private key, which it's only when the private key is combined with the public key that the system can be changed to show that the digital asset is associated with somebody else's public key. And the control comes from controlling the private key normally. So Bitcoin and Ether, but they're also, and we discuss this a lot in our principles, the fact that digital assets in the way we've defined it can be linked to other assets, such as, for example, a security, a share or a bond, a debt security.
Or by pen, for that matter.
Or your pen, well.
Yeah.
And one of the things that is still a matter, we're not going to the UNIDROIT project doesn't cover this in detail, but one of the things that we would say is this is up to other law, because it will always depend on national law as to whether that link can be effective legally or not.
Right. So if I may interrupt here, so what we'll be talking about together today would be the holding of the digital asset, right? So that's the digital asset, that electronic record,
Exactly,
rather than the
link.
security or the pen
That's
that
right.
is linked to that digital asset, right?
And matter which probably we won't get onto, but obviously there is also a question of whether the custodian or whatever we're talking about custody holds that other asset as well. But that's as it were
Right.
a separate issue and is linked, is very dependent on the nature and effectiveness of that link. So I think you asked me about holding digital assets, and I mean, holding is a bit of a loose term, and it's not really very defined anywhere in particular, but I think most people know what we mean when we talk about holding. You know, how do you sort of either how do you own something, or how do you sort of get hold of it, as it were? And there are various ways of holding digital assets. One of them, certainly on a blockchain system, is actually being a node on that blockchain, to have the whole blockchain or part of it downloaded on your computer, and you're one of the people who changes the state of it. And you may well be, in that case, certainly in case of Bitcoin, mining that Bitcoin, and it will be yours until you transfer it to somebody else. We're not really interested in that. That's a very niche area. There are also what we...
So then maybe, sorry to interrupt again, but so that will be a situation where the holder is also the owner, right?
Absolutely,
right.
absolutely, absolutely.
From my jurisdiction, for instance, in the Netherlands, lawyers would have attached specific meaning to holding, and holding then would mean, per se, holding something for somebody else,
right?
And but to be very clear on this, because that's not what
that's not what we mean here. I mean,
right.
and in fact, so I mean, I think the word holding is used in, that's why I say it's not a very term of art, because it's used in different contexts in different jurisdictions. I mean, we use it in relation to nothing to do with digital assets, intermediated or non-intermediated securities. We would say that if you have a share or a bond in the UK, which is held through Crest, which is a registration system, that's direct holding. And so nobody else has any interest in that asset except the person who's registered as the owner on that register. And that would be a direct holding as opposed to indirect holding. This is why the word holding, unless defined, which is one of the things that we try and do a bit in the principles, is not it's not a term of art. And I agree with you, it could vary from jurisdiction to jurisdiction.
Right.
There is another way in which a person, and by a person I mean individual or a company, any legal person, can own and hold a digital asset which doesn't involve any other intermediary, doesn't involve anybody else. And that is what's sometimes called a non-custodial wallet, effectively where the owner controls the asset. So the owner controls the private key. I talked about digital assets being controllable, and controlling the asset normally would mean that you would have exclusive control of the private key. Sometimes there are things called multi-sig arrangements where more than one person can have some form of control over the private key, and there isn't anything really to stop anyone sharing their private key with someone else. But basically, if we talk about exclusive control, we basically mean one person or one person with others that they've chosen to share it with. So if the owner controls the private key, then there is really only one person involved, and that's the owner, and that's what I would call direct holding. And we're not going to talk about that either. And what we are going to talk about is two other forms of holding, if we can call it that, which are both can look similar from the outside, but have different legal consequences. And the form I just talked about, the wallet, again, would be a matter of law as to whether you have a wallet where the owner, matter of law and fact, who have a wallet where the owner controls the private key, and what the relationship is between the owner and whoever it is who provides the wallet. It could be an off-chain wallet, a tangible wallet, effectively, cold wallet, cold storage, they call it, and then it probably would be governed, for example, by a sale of goods contract or something like that. Or it could be a software wallet, or a wallet that is some form of software that is on the computer, either online or offline, and then it would be a provision of certainly what we might call digital content or software, which would again be the subject of contract. Normally these things And so the relationship between the wallet provider would be just a contractual relationship. So I don't think we need to think too much about that. Talk if you like. Then there are two other ways of holding, which, as I say, look very similar. And this is where another party who isn't the owner or isn't the client, let's call them the client, because owner is
or investor maybe.
Sorry?
Or investor
maybe the investor. Let's call them the investor, the person who is the client of the other parties. Yeah. And the other party controls the asset, and the investor doesn't, effectively. So either the investor gives the asset to the other party, or the other party acquires the asset on behalf of the investor.
Right. So that would be a typical crypto exchange scenario where you would ask or instruct the exchange to acquire, to buy some cryptocurrencies or rather digital assets for you.
That's right. And they would control that asset for you. Whereas a custodian, I mean, a sort of probably a relationship that was actually called custody by the parties as opposed to an exchange would be more a matter of where the client might already in some way control the asset and kind of gives it to the custodian to look after it.
Right. I mean, but the effect could be
the same.
Very much similar, right? You have your phone and then you see what's on your crypto account, and that could be both scenarios, which are legally very different, if I understand.
Well, I mean, whether the other parties calls themselves a custodian or an exchange is probably pretty irrelevant from the legal point of view. At least we would say that. The thing that really makes the difference is
from the private law perspective.
From the private law perspective,
right.
Yes, absolutely. So that's what we're going to talk about, isn't it? We're going to talk about private law.
Because I could imagine that from a regulatory or supervisory perspective, there are huge differences between a custodian and an exchange,
exactly, and they may have different licensing requirements.
Service provider you would have.
Exactly. So, but for what we're interested in is the relationship between the custodian and the client, and the consequences of that for the what we might call proprietary consequences, or consequences of that. I'll mention in a minute that come from the characterization of the agreement. And the agreement, well, normally it would be the agreement, or maybe the agreement plus some background facts, would determine whether the custodian merely controls, but the client has some form of proprietary right in the asset, which would mean that when the custodian becomes insolvent, the asset doesn't form part of the custodian's estate. I mean, that would be one of the main reasons why we would want to know the difference between this type of holding and this type of indirect holding, where there is an intermediary involved, and another type of indirect holding, which is where the custodian or an exchange doesn't just control the asset, but actually owns the asset. And all the client has is a personal claim, no proprietary right, just a personal claim against a custodian or exchange. And that typically, though I think sure it would depend on the situation and possibly the jurisdiction, is the way banks work. As we all know, that all you have is a claim against the bank, a personal claim, that you don't have any proprietary right in a typical bank account. So it's really the difference between the client having some form of proprietary right, which means that the asset doesn't form part of the custodian's insolvency estate, and a banking type situation where the custodian has all the proprietary rights and control of the asset, and all the client has is a personal claim.
Yeah. So I immediately see that there are huge differences in legal situation between the two. I could also imagine that it can be quite tricky or difficult to determine exactly into which of the two scenarios we're actually talking about, and also from the perspective of an investor who usually, you just enter into agreements or ask your exchange or custodian to buy crypto assets for you. You don't read all the fine print, I can imagine, because if I understand you correctly, that's where the difference will mainly come from.
Yes.
Right? The fine print saying the custodian is either not only controls it but also owns it, versus the other situation where it's controls it but not owns it. So that there is huge differences in a possible insolvency.
That is right. And I mean, I think one would be slightly optimistic to think it might even be in the fine print. I mean, many agreements, as I understand it, don't say anything about this at all. And so you have to look at all the other terms of the agreement and try and work out what you've got. I mean, there have been some cases about this in the common law world. And I should say that the consequences of whether it's one or the other of these two different ways, I mean, there's the insolvency consequence we've talked about, but other consequences could be, depending on your jurisdiction, the nature of the duties owed by the custodian or exchange to the client. So we have a Singaporean case where they were looking at the nature of the duties and whether it was common law breach of trust. And there the court decided that it was in fact one of these bank-like arrangements, and there was no trust because it was just a personal claim. And then we had a New Zealand case, and in the New Zealand case, the court decided that it was what we would call custody, and the asset, because it was common law jurisdiction, was held on trust for the client. And they looked not just at what the agreement said on this matter, which in both cases was pretty silent. They also looked at all the other terms of the agreement and tried to work it out.
I would think that that's really, well, not materially different in civil law jurisdictions.
Yeah.
The big difference between, as we talked about already, between somebody holding assets for somebody else and somebody holding and owning it, or have more proprietary interest in that.
I mean, I think that's absolutely right. But it is, as you say, it is a problem, particularly for investors who are either individuals or, aren't likely to read small print and so on.
Yeah, and I would, in many cases, would have the expectation, would think, that when the exchange or custodian falls over, they would be able to reivindicate or get back in any formal way their assets.
Their assets.
Just as they would have if they would hold or buy securities, stocks and bonds.
Absolutely. And I think that there are various ways of dealing with this. I mean, and one should say, I think I should just quickly say that there possibly are advantages in the bank-like structure as well. Which means, for example, that if you have the bank-like structure where the client has no proprietary rights, it gives the intermediary much greater freedom to use the assets to make money, which can, in one sense or another, be passed on to the investor, rather, as banks do, and so on. So it's not completely one-way street. It's just that what is necessary is that people understand what their position is, and of course, if these custodians and exchanges are operating where all the client has his personal claim, then there is scope for regulation of that in a different way than you might get from a custodian where the client has a proprietary interest. Now that's regulation, and that's nothing to do with our UNIDROIT principles. But what we did have thought about in the UNIDROIT principles is to put in, and we have put in, a presumption in relation to the interpretation of this agreement. Because we are aware at the moment that most agreements don't say anything about it. And the idea is to try and suggest a system for states so that there is an incentive to at least make the position clear. This is not a regulatory requirement. This would just be saying that this is the way an agreement would be interpreted. And what we say is that if the services are provided in the course of business, so intermediaries acting in the course of business, that the intermediary is obliged to obtain, if that's not yet the case, and hold the digital asset on behalf of the client. So that, as it were, that's what they're doing from the outside under the agreement, and also that it's the intermediary that has control and not the client. So the client doesn't have the exclusive ability to change control.
Right.
So if the client doesn't have control, if those three things are satisfied, we're saying it's presumed that it is the type of holding where the client is protected on the insolvency, unless that's made clear in the agreement.
Right. And these are or will be internationally accepted principles or rules of law. I could imagine that, and that's the topic that we will turn to in a minute, I think. I could imagine that under national laws, national jurisdictions would approach this issue rather differently. Are there big differences to your mind, or?
Well, I mean, what
I mean,
we're suggesting.
these principles are the product of international acts.
That's right. And what we're suggesting is that this will be best practice, and this is
right.
kind of what we would expect states to say in their rules. Of course, I mean, it is certainly possible for jurisdictions to deal with it differently. I mean, and this is something we might talk about later, which is, so under English law, for example, we now approach the interpretation of contracts usually without strong presumptions. I mean, we used to have a rule called contract offerendum, where you have an unequal bargaining power, and the contract seems quite unequal, where you would interpret it against the person who has all the power,
yeah.
and that's
which is also known in EU law and EU consumer law.
Exactly. So in general terms, in the UK, that's on the way out, although not necessarily, as you say, in consumer legislation and so on. I mean, consumer legislation is usually slightly different, and it's also in English law legislation as opposed to being just case law, which is where we get the interpretation from. But I agree with you, and of course the other thing that you would get sort of sitting on top of this private law is probably some form of regulation. In the same way as we have regulation, for example, about title transfer collateral arrangements, we do, and I think most European countries do, which say that retail clients can't enter into title transfer collateral arrangements except in very, very limited circumstances. I mean, that's nothing to do with what we're doing, that's regulation.
Exactly.
So.
And I would think that the difference mainly lies in the consequences, for instance, of a breach of the rule.
Yes.
Yes. I mean, I think breaches of the presumptions here, or the rules that these principles contain, will have consequences on the private law, so that certain consequences do not materialize. Transfer law doesn't transfer the digital assets and so on, rather than somebody having to be subject to a fine, or having to be subject to a retraction of its license. Exactly.
So regulation is very different, but of course they both can focus on the same problem. I mean, the thing about the presumption is that it's more to do with how the agreement is characterized, which is why I think it's interesting from the contract law's point of view, as opposed to being a duty. There's no duty to say you absolutely have to say what type of agreement it is. We're just saying if you don't say what it is, then it's presumed to be the one that's most beneficial to the client. We've suggested it. I mean, we ought to get on to perhaps the conflict of laws point, but just a couple of other matters that issues that also arise with custody. So, I mean, there are also sort of general proprietary issues that arise with custody. So, if the asset is stolen or hacked, so taken by someone who hacks into the situation, into the system, and then transferred to a custodian to hold it on behalf of a client or something like that, then there are those types of issues, and whether the acquirer gets good title, whether there should be whether there's a taking free rule, those sorts of issues, which are nothing really to do with the fact it's held through a custodian, or for that matter, whether the client who transfers the asset to a custodian to hold for them, whether the client owns it in the first place. The custody situation has nothing to do with that, but obviously law, there needs to be rules, and there will need to be conflict of law rules on that.
And again, custodian here also can mean an exchange.
It can, that's right. We just, I mean, a custodian, the way we talk about the principles, and one tries to have one word instead of two, but it's absolutely clear to us that many exchanges are custodians in the sense of holding these assets in a way that it doesn't form part of their insolvency estate, but they still control the asset. The other situation where issues arise, and a number of different issues, is where assets held by a custodian and then they are given as then somebody else takes a security right over them. So they're given as collateral, or they're used as collateral emanating from someone else. And there you would also need to have rules about the way that would work. I mean, obviously you need rules about how taking security works in relation to what I've called direct holding, where somebody controls and owns the asset. And it's just a question of how do those rules pan out when the asset is held through a custodian.
And another complication, which is well known in the context of intermediate securities, is when the custodian itself will be the security holder.
Absolutely, absolutely.
And then you might, there might be different ways of creating a security interest in that particular context.
Yes, that's right, and I mean that's a very common situation, as you say, and very important. One of the other things we think about in the principles is how you can make the security right effective against third parties. And what we're suggesting is that it can be done by the party taking security, having control of the asset, and what that means we've sort of fleshed out in the principles. But I mean, one way would be for the if the intermediary is themselves the secured party, then they will already have control of the asset because they control it for the client. And so, which fits in actually with the way it works with intermediaries.
Indeed.
So we probably ought to have lost track of the time, which is probably good because it's very exciting to talk about all of this. But we probably ought to move now on to the issue about what conflict of laws rules should apply to these issues that we've been talking about. So far, we've been talking about it as though we're all in one jurisdiction and absolutely everything is applied. You know, there's one kind of jurisdiction as law. So first of all, Matthias, I mean, if we think about conflict of laws, I mean, there's various general principles that one might say, how are we going to come up with conflict of law rules? So maybe you'd want to say a bit about that.
Yeah, gladly. So I think maybe first by way of introduction, to some people it might seem counterintuitive to talk about conflict of laws or the applicability of any national law when we talk about digital assets, because I think when you think about how digital assets came about, the idea was to have these decentralized assets, at least with Bitcoin, decentralized assets with no interference by governments and having the system itself determine its rules rather than having a particular national law apply. But I think that, well, especially from a legal perspective, considering how this works, and also from the perspective of how to adequately protect investors in digital assets, I think it's absolutely critical to acknowledge that in critical situations, you would have a national law always apply in order to be able to answer important questions such as who owns the asset, for instance, when a custodian falls insolvent.
Yes.
Those are no matters that can be regulated by smart contracts or by normal contracts. You cannot contract around a lot of those issues that we have already been talking about. These property law issues are usually of mandatory nature, which just apply as a matter of law. So that's why I do think the conflict of laws analysis is important.
Absolutely.
And maybe even more so because at present, it is rather unclear in many jurisdictions what exactly is the national law applicable or how it should apply to digital assets. So it's unclear. There are big differences between national laws on this matter. So that all, stresses the importance, I would think, of a decent or adequate conflict of laws analysis.
Yeah, and one thing I didn't say, perhaps I should have said at the beginning, is that we are assuming, and this is what we assume in the principles, but it's also true that is being assumed by many jurisdictions, is that digital assets can be the subject of proprietary rights. So when we talk about property law issues, we are assuming that there can be property law issues in relation to digital assets.
Indeed.
And I don't think we have time to explain why we say this is the case, but I mean, there are good reasons for it. But if it was not the case, then most of what we say is completely irrelevant because we're talking there about things that can't be owned. So
on a personal note, I would think, I mean, well, maybe theoretically, it could go both ways, maybe either contractual or indeed being property, as I think an English lawyer would say. But for me, one of the main reasons to go and prefer the other route, that is considering digital assets to be property, is from the perspective of the investor and its expectations as to what happens when the custodian, topic of our talk today, falls insolvent.
Absolutely.
So I would really think that it would be contrary to party expectations when you would say, well, okay, this custodian falls insolvent, the exchange falls insolvent, and you have a mere contractual claim, and you have to stand in line with all the other creditors, also the creditors of the exchange itself.
Yes.
So that's why I would.
That
it was one of an important reason.
It is an important reason. That's right. But I think also another important reason is that you can then take security interests, security rights over these things, which increasingly have become important. Anyway,
but indeed, I fully agree with you that stresses a conflict of laws analysis even more, because that makes it because then we're in the realm of property law and mandatory rules, which differ from jurisdiction to jurisdiction, and why a conflict of laws analysis is even more important than if you would say it's all a matter of contract, because party autonomy is allowed to a far greater extent in that context, as opposed to in the context of property.
Absolutely.
interests.
And I think the other thing to stress is that certainly the way we looked at it in the principles is that it's very, very unlikely that there will be and we haven't done this in principle, there'll be a completely new code that will be accepted by every country in the world to do with digital assets. So actually, there will be certain new rules when countries decide to have a private law of digital assets. Most of the law that applies is their existing property law.
Right.
And as we know, there are quite a lot of differences between existing property law in general.
Exactly right.
And that's not going to go away just because we're talking about digital assets.
That's the paradox of conflict of laws unification projects. I mean, if we would all have the same substantive law, there would be no need for conflict of laws, but that would be, well, highly unlikely. And, and we continue our talk on the basis of that assumption.
Yes, absolutely.
All right. So the other thing to say, maybe that's important before we go into the specifics of what conflict of laws rule could apply to these matters, is that as a matter of principle, and because of the nature of digital assets, it's rather difficult to come up with a very a conflict of laws rule that would come naturally or flow from the nature of the asset, because the asset itself is an intangible asset. It was intended to be held across borders. It was intended to exist only, well, not have any physical presence. And that makes it really difficult to find a conflict of laws rule, especially because the traditional conflict of laws rules regarding proprietary issues usually connect with the place where the asset itself is located.
I think we perhaps just ought to make it clear that not every single one, but most of these assets are held on distributed ledgers, which means they're held on lots of different computers, and those computers individually could be in any country. So we're not just talking about cross-border in the sense of two jurisdictions. We're talking about often assets that are held in many.
Yes.
So the computers are in many countries.
So that ingrained in the nature of the asset itself, if you like, and that makes it very difficult to come up with a conflict of laws rule regarding proprietary issues. But it is really important, as we've already established. And I think well, when thinking about which rule then should be the best rule, would be the best rule to apply, a very important principle would be to look for a rule that is both predictable to parties and gives certainty to the greatest extent possible as to what law then would apply in these situations that we envisage. So certainty and predictability, those are the leading principles when thinking about which rule to apply, which conflict of laws rule to apply. But that's not an easy or straightforward matter.
No.
Yeah. The other thing is, which I think is really important, is to distinguish between the matters at hand. That is, we've so far rather loosely talked about proprietary issues, but we zoomed in on the creation of security interest. We briefly zoomed in on an insolvency situation. But I think it would be really important to think through the various scenarios that might materialize when drafting a conflict of laws rule. because they play out rather differently. If, for instance, a court in taking the insolvency situation that we already touched upon, so we have a situation where a crypto exchange falls insolvent, and some of them did.
Yes.
Exactly. So it's not a completely theoretical scenario here. And then a court would typically be faced with difficult questions, but it would really depend on how the questions or the issues that are brought before the court, how those would be phrased by the parties, and how the court would characterize those issues. For instance, if the matter would be which digital assets form part of the insolvent estate, that would typically be considered to be a typical insolvency law matter, so that insolvency law conflict of laws rules would apply, which tend to be different from a question such as who owns the assets.
Yes.
Because that would be considered a proprietary or property law question, to which typically other conflict of laws rule would apply. They may end up in the same law having to apply, but not necessarily so. So I do think it is important to think through which would be the most obvious issues to be brought before a court, and make a sharp distinction between those. So indeed, who owns the asset, who is the owner of the asset, would be an important one. Also, outside of the insolvency context, for instance, if we have a transfer of a digital asset, there could be an issue of, has the transferee become the true owner of the asset?
Exactly. And I think, as I said, even in a custody context, that kind of issue could come up, because you've got the position between the custodian and the client. But of course, there might be somebody else who says, actually, that's my asset, and this client never owned it in the first place. And then, so you could have that type of issue that wasn't a custody issue, but would be irrelevant in the custodian's.
Exactly. Indeed, a typical example would be if a security interest would be granted on a digital asset held through an exchange or a custodian, and the investor creates a security interest in favor of, or to the benefit of his creditor, who then is another party than the custodian itself.
Yes, exactly.
So then it's a typical situation which may create difficult questions and conflicts of laws, because the law of the custodian, or where the custodian is located, if we can establish that, can be quite different from the law of where the creditor is located. Can be different from the contract between the debtor and the creditor, or the investor and the creditor. So there are all kinds of different laws that may apply in this rather straightforward case. Which may give rise to very difficult questions.
Some of them, of course, well, I don't know, perhaps you're going to go on to this, but I mean, as long as we're talking about areas that are not digital asset specific, then we already have rules for this kind of thing, don't we? So we might say, well, I mean, I think you might be going to talk about conflict, but generally we have rules about how we decide.
That's absolutely right. That's absolutely right. So if we take this scenario a little bit further, where you have a digital asset held by a custodian, and then a security interest created on that digital asset to the benefit of a creditor, then I would think that typically, also outside of the digital asset context, the contract between the debtor and the creditor, the contractual issues, would be governed by what I think English lawyers would call the proper law of the contract.
Yes, exactly.
So those are contractual issues in the EU. Those would be governed by Rome I regulation, and there is to a great extent, parties are free to choose which law applies to those issues. But then the difficulty is, so the principle would be contractual issues, the issues, interpretation of contract, the validity of the contract, what happens if contractual obligations are breached, those types of issues typically governed by the law of the contract.
And what we don't want is a sort of separate set of rules relating to digital contracts relating to digital assets. We want to harmonise with the rest of the law.
So the main principle should always be you build on the generally acceptable conflict of law. So that would be, to me at least, would be the starting point to indeed acknowledge this difference between the contractual issues and the proprietary issues. And that sounds rather straightforward, maybe at first sight. But then, for instance, in the custody context, it's not always so straightforward. What exactly is the proprietary issue and what is the contractual issue? I think you explained this really clearly, that from how the contractual relationship is shaped and how it is interpreted may follow proprietary consequences, which then in itself would be governed, or the questions that arise in that proprietary context would be governed by the property law conflict of laws rules, rather than the contract. The conflict of laws rules that typically apply to contractual issues.
And a question is, I suppose, where you draw the line, because obviously the consequences of the proprietary conclusion would be governed by proprietary conflict of laws. The question is what governs the question of whether those proprietary issues arise in the first place, or whether there is a property right.
Indeed, and I would think in the typical conflict of laws analysis, I think that would maybe to some extent be an issue of qualification. So qualification by the court, interpreting what is the matter at hand here, what is the issue that the parties have brought before me, and then that goes back to how the issue is framed, as we said earlier. So I think the first thing for the court would be to establish, is this a contractual or a property law matter that has been brought before me, and that may be informed, that analysis may be informed by his own law as a matter of lex fori. So he would look at the matter from his own, with the lens of his own national law, that is the national law of the forum. So I think that would come into play also in this very important distinction that must be made, even before going into what type of conflict of laws rule would we have to apply to a property law matter.
Right. Okay, so perhaps we could turn to that now. I mean, what are the contenders for the possible conflict of laws rules? Yes,
and here I think it would be good also to as you have done also, is to distinguish between the situation where somebody owns and controls the digital asset himself, and the situation where the asset is held through a custodian. So I think also from a conflict of laws perspective, that is a very relevant and maybe determinative distinction. So if we first think about the situation where the asset is held directly by the investor, I think typically, well, as I said before, typically in property law matters, you would tend to look to the place of the where the asset is located. But we've already said that's virtually impossible. Virtually, because it's virtual. The asset itself. So it's from a practical, but I think also from a dogmatic or theoretical perspective, impossible to use that rule. Trying to look at the location of the asset. But because it is a property law matter, and you typically want to, well, for questions such as who owns the asset, is a security interest in that asset validly created, is it opposable against third parties, and so on, I think you would have to look at the asset itself. That would be the typical connecting factor. So first contender for a conflict of laws rule would be to look and see whether we can find the law that applies to the asset itself. So it may be that when these assets are created, on the blockchain or on whatever medium, that there is a choice of law may be made or can be inferred from how that digital asset has been created.
Yes.
So that would be a first rule that can be formulated, and I think we also do so in the UNIDROIT principles.
And that would, if that were done, give certainty and predictability, because all you have to do is look at the asset and it will tell you what the law was.
Yeah, absolutely.
As long as there was such a choice, that's.
Yeah. So and that would be readily knowable for other parties to see which law applies to those important questions.
Yes.
Whether a security interest is validly created or who owns it, and whether it can be retrieved in insolvency, perhaps also. Yeah, indeed. Another possible rule could be not so much to look at the asset itself, but more to the blockchain or the system on which the asset is created.
Yes.
Because as you I think already quite rightly said, it is not always the case that creators of digital assets determine or express which law applies to the digital asset itself. So it might be that there has been made a choice of law for the system or the ones that operate the system. So a choice of law may be expressly made. That could be possible. Could also be that can be inferred. For instance, there are crypto systems which are very much intended to operate within a certain jurisdiction.
Right.
When you think, for instance, about maybe digital currencies of a specific jurisdiction, which are to operate only within that jurisdiction, operated by cryptocurrency service providers located in that very same jurisdiction, I think it would be contrary to expectations if you could say, well, another law could apply then the law of that very jurisdiction. So that could be a second contender for proper or an adequate conflict of law regarding the proprietary matters, that is, having the law of the system apply.
But then, of course, if you don't have that and you don't have the law of the asset, where do we go from here?
Yes, that's a tricky one, and we have to be a bit creative there, I think. And again, maybe different scenarios should be distinguished. But also think of when we think of transactions such as security, where a transaction in which a security interest is created, you could think of rules which say the law of the security provider, where the security provider is located, would apply. So, and that's a rule that has been adopted, for instance, by the European Law Institute and by UNCITRAL on other matters.
Yes. And you can see in particular that if you have a security interest that is perfected by registration, made effective by third party by registration, then that probably would have to be governed by that sort of rule, because you have to know where to register.
Right.
You need to have a location, and you need to know where, and it would normally be where the debtor, where the security provider was, I suppose.
Yes, yes. There are also jurisdictions, such as my own, which say in the context of, for instance, a security interest created in a receivable, which say you have to look at the law of the security contract, so the contract between the debtor and the creditor. So you have not only that contract govern the contractual issues, but also the proprietary issues. So that's maybe even a third contender in that specific context. Yes. So there are different possibilities here. If nothing works, which is absolutely foreseeable. So that is if the issuer of the digital asset is there, if there ever is an issuer of a digital asset. Sometimes it's very decentralized. No conflict, no choice of law can be has been made or can be readily inferred or knowledge knowable when there is no when the system is really international cross-border, no obvious choice of law has been made in that context. You need to resort to, well, the bottom of the waterfall, as we call it.
Yes.
Which may be the rule that applies most. A possibility would be to have internationally accepted rules of substantive law apply, such as maybe the UNIDROIT principles.
Right. So let's just move on to where the asset is held with a custodian or an exchange, because and where the custodian exchange has control, which is what we were talking about earlier. Perhaps probably well, I don't know, we're talking about both situations, perhaps, are we, where the custodian, where it doesn't form part of the custodian's insolvency estate and where it does. So what law would we be looking at then? Yeah,
indeed. And so I think, well, what we said earlier on is and I think these situations are really different.
Yes.
So I think as has been accepted in the context of intermediate securities, it would be more in line with party expectations to look at the relationship between the investor and the custodian, rather than to look elsewhere.
Yes.
And it's specifically so because the investor cannot dispose of the asset without the custodian.
Right.
So specifically in this property law context, I think that is really a very strong argument to say you have to look at that specific relationship between the investor and the custodian, because the investor can do nothing with the asset if not through the exchange.
Yes.
So that's why I think that would be the appropriate place to look at that relationship, and then also what we already referred to, the context of intermediate securities, where it has been accepted that you have to look at well, that relationship, and then there are different ways to do that.
Yes.
One of them being look at the contract between the investor and the exchange, and have also that contract also a bearing on the property law aspects of how the digital asset then is held by the exchange. I have to say that in the intermediate securities, that by no means globally accepted.
Yes.
But a way to mitigate, because some jurisdictions feel very strongly about this, say, well, that is too much party autonomy in the property law context. So then a way to mitigate this, if you feel the need to, would be to look at the place of incorporations, for instance, of the custodian or the exchange.
Yes, or the place of business, or however we.
Indeed. And interestingly, in the digital context, those exchanges are locatable if you like. So and here maybe also the regulatory side comes in, because we see more and more regulatory rules being enacted, because supervisory authorities see this as maybe a threat to financial stability, etc. So they create more and more regulatory rules, and for that purpose they would, well, rightly so, require that those service providers have a location so that they can be fined or whatever.
Exactly, and it will be easy to determine that location, because both because they're regulated and because they will have to declare that on.
That's exactly right, and that has important consequences also for our purposes here, because then we would have a clear location, and then you could say, well, if not the custody contract between exchange and investor determines the proprietary issues or the proprietary questions, so you would have a readily available jurisdiction.
Yes.
And look at that jurisdiction, say, well, that national law applies to the questions that we've been talking about.
Yes. So I think we are getting near the end of our time slot. Is that right, Geraldine? And so I think we probably ought to wrap it up there. I don't know if there's anything more you want to say about this. This is a very difficult issue. It's very much work in progress in terms of some of these issues.
Absolutely.
Particularly in relation to custody, where we haven't been discussing this at all very much at the UNIDROIT level.
I think that's exactly right. So we've been talking about various contenders for the best rule, but I do think it is important to think about this, especially exactly for the reasons that we've been discussing, and also to come to a sort of international conclusion as to what would be the best rule to apply, because it's so important and so critical. I think also for the coming years, because we all see that this is an important topic. Digital assets are becoming more and more important, and we have to acknowledge and realize that national law applies to these very difficult but important questions.